Hello, KASA members. I wanted to thank you for participating in the Law and Finance Conference last week. And because we try to keep you up to date on the latest legal happenings around the country, we thought this would be a good moment to jump in with a quick video that gives both some analysis and some practical advice about the Endrew F. case that just came down from the United States Supreme Court. The reason that we wanted to do this is a really important case for us in schools to begin to process. And you're going to get a lot of analysis from a lot of different sources, and that's excellent. And you should also be consulting with your school board attorney on any parental issues emerging as a result of this case, because ultimately this is a case that sort of ruled against the school district in the benefit that's being provided in the special education case. Now, this particular case involved a private placement, an expensive private placement, that resulted from the school district concluding that there was no benefit to the IEP that the district was offering. As such, they went to a private placement in Denver, and the school had to reimburse for that private placement. Now, what's important about this case is that it brings new meaning to our long-standing underlying law on the Rowley decision that outlines what the free appropriate public education means. FAPE is the foundational guarantee of the special education law. And so what that means is really important. And historically, that has meant the child receives some educational benefit. That was what the Rowley case determined now a generation ago. And over the last generation, courts have interpreted that in slightly different ways, but generally finding that there has to be some, meaning more than minimal, educational benefit in the IEP in order for the child to stay with the public school and not permit that type of private placement reimbursement that we saw in this case. Well, in a unanimous decision written by Chief Justice Roberts, this case now takes that slightly a step further. It does a few things. Number one, it clarifies with a lot of clarity that the substantive guarantee in IDEA is a substantive guarantee that is focused on student progress, not as much focused on what the school is offering. I think that's a new, slightly different component of this decision from Chief Justice Roberts. But more specifically, and the area that you're really going to feel it, is defining FAPE as reasonably calculated to enable the child to achieve passing marks and advance from grade to grade. And later, that sort of same definition is said this way. FAPE means an educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Okay, so it's not a bright line rule, but it brings the word reasonably calculated into the equation around what progress the child is making. And thus, the IEPs going forward, now switching a bit into practical advice, the IEPs going forward as we craft these in our schools need to be clear about what educational benefit has been reasonably calculated inside of them. And I think there needs to be very clear steps that the child is taking forward in each year's IEP. Specifically, the practice of sort of copying last year's IEP and just slightly changing a couple of things. That practice seems to be in question going forward. And there's just going to need to be more clarity about what steps, what educational benefit the child is receiving each year in the IEP, and then what educational measures are going to be in place to support the child actually making those steps. All right, so that's a new burden, I think, on schools that we all are going to have to come to terms with. Now, the flip side of this is the Roberts Court could have gone further. The parents' side actually requested a harsher standard on schools that really force schools to actually achieve these educational benefits. It did not go that far. Okay, so this is a step forward for parents' rights and student rights in special education, but it is not a massive step forward. And it's not something that we as schools need to change our entire way of operating around IDEA. We just need to be more clear, and we need to coach our special education staffs to be more clear about the educational benefits that the child is receiving, and assuring that each year a child is taking a step forward in those educational benefits. We as school people are good at sort of dissecting steps in an educational journey and sort of layering those steps. That we're going to need to use those skills as we formulate these IEPs to sort of show these are the steps that the child is taking on their educational journey on both academic content standards and on sort of dispositional life habit type stuff. I think that's what the Endrew F decision is going to mean for schools. That's just my interpretation. We wanted to get that out to you, though, as a thank you for participating in the KASA Education Law and Finance event, and we look forward to seeing you next year at the conference.